Hi, we are the GSA Office of Civil Rights. Civil rights requirements can sound intimidating, and sometimes when you see them written down, they feel much more complicated than they need to. Our goal today is to break this down in a way that feels practical and understandable, especially for those of you who are not working in this space every day. At a high level, our office is responsible for enforcing federal civil rights laws and regulations that apply to programs and activities receiving federal financial assistance from GSA. Today's session is really meant to be foundational. It is not legal advice, but it is meant to give you a clear picture of the expectations that apply to GSA recipients and how those expectations can come up in day-to-day operations. We're going to cover four main areas today: the key civil rights laws that apply to GSA recipients, some recent updates and what those changes may mean for you, general recipient responsibilities, including the kinds of policies, procedures, and practices organizations should have in place, and finally, we'll go through a few practical scenarios to connect all of this to real-life situations. I also want to say at the outset that this training is part of a broader outreach effort. Our goal is not just enforcement. Of course, enforcement matters, but we also want to support compliance by making sure recipients understand what is expected of them. Before we get into the specific laws, I want to define a term that I'll use throughout the training, and that is the term recipient. For purposes of this session, a recipient is an entity that receives federal financial assistance from GSA, either directly or indirectly. For context, that includes the SASPs and the donees that receive surplus personal property, and recipients of real property under the Public Benefit Conveyance Program. More broadly, federal financial assistance can look different depending on the agency. It can include things like grants, loans, cooperative agreements, or property. So the key takeaway here is simple. If your organization benefits from federal assistance through GSA in any form, these obligations apply to your programs and activities. With that foundation in place, let's get into the specific statutes. The first core civil rights law we'll cover is Title VI of the Civil Rights Act of 1964. Title VI prohibits discrimination on the basis of race, color, and national origin in programs or activities receiving federal financial assistance. At its core, Title VI is about making sure that recipients do not deny benefits, limit participation, provide different treatment, or otherwise discriminate in the administration of their federally assisted programs on those bases. So, what does that mean? It means organizations should make sure their policies and procedures do not intentionally treat people differently based on race, color, or national origin. Access to programs and services should be provided on a non-discriminatory basis. And it means organizations should have complaint procedures available for individuals who believe they have experienced discrimination in one of the organization's programs or activities. This is really where compliance becomes operational. It is not enough to simply say that discrimination is prohibited. Recipients should also be able to point to the policies, procedures, and staff training that support that commitment in practice. From a practical standpoint, recipients should still take a close look at several internal areas: written policies and procedures, intake and eligibility practices, outreach materials, complaint procedures, and staff training. The goal is to make sure those processes reflect non-discrimination requirements and that staff understand how to apply them consistently. That covers Title VI, but I also want to transition to an issue that many recipients may be hearing about right now, and that is language access. Recently, Executive Order 14224 designated English as the official language of the United States. Following that executive order and guidance issued by the Attorney General in July 2025, federal agencies were directed to revoke prior limited English proficiency guidance and related policies that were inconsistent with that direction. As part of that process, GSA revoked its prior language access policy and issued a new language services policy. Under that policy, GSA provides language services only if it is mission critical. So what does that mean for recipients right now? At this stage, we are still waiting for additional guidance from DOJ regarding how these changes will apply more broadly across federal financial assistance programs. And in the meantime, recipients should continue operating consistent with applicable federal and state requirements. There is an important caveat here. Disability-related communication access has not changed. So if an individual is deaf or hard of hearing and needs an interpreter or another aid or service, those obligations remain in place under Section 504. Those requirements are separate, and they have not been eliminated by the recent language policy changes. Next, let's discuss Section 504 of the Rehabilitation Act of 1973, which addresses disability discrimination. Section 504 of the Rehabilitation Act prohibits discrimination on the basis of disability in programs and activities receiving federal financial assistance. For recipients, that means programs and activities must be accessible to individuals with disabilities. That includes physical accessibility, program accessibility, effective communication, and reasonable modifications where needed. And unlike some of the recent changes we just discussed under Title VI and language policy, disability access obligations remain largely unchanged. When we talk about accessibility, we are talking about more than just whether a building is up to code. We are really talking about whether individuals with disabilities can meaningfully access the programs and services being offered. That can include things like accessible routes where the public is permitted, accessible restrooms if restrooms are offered to the public, appropriate door pressure and maneuvering space, and compliance with the applicable accessibility standards. That is also why, during compliance reviews, we often ask whether you operate a physical or virtual program. For example, if you operate a warehouse and members of the public, including donees, are expected to come to that warehouse, then we need to think about whether those individuals can access the space and participate in a meaningful way. Section 504 also requires recipients to ensure effective communication with individuals with disabilities. That means recipients should have processes in place for communicating effectively with individuals who are deaf or hard of hearing, individuals who are blind or have low vision, and others who may need auxiliary aids and services. And I want to emphasize this because it sometimes gets blurred together with the language access discussion. Disability-based communication access remains unchanged. Executive Order 14224 relates to foreign language communication. It does not eliminate or reduce your obligations to provide effective communication to individuals with disabilities. A related issue that often comes up in practice is service animals. Recipients generally have to permit service animals in areas open to the public. A service animal is generally a dog that has been individually trained to do work or perform tasks for a person with a disability. In some contexts, miniature horses may also come up. What staff cannot do is ask for medical documentation, require proof of certification, require proof of training, or ask about the nature of the person's disability. What staff can do is ask two limited questions. First, is the dog required because of a disability? And second, what work or task has the dog been trained to perform? That is it. This is why staff training matters so much. These situations usually happen at the point of entry, with frontline staff making a judgment call. And if staff are not trained, that is often where problems happen.
To recap, when reviewing compliance under Section 504, recipients should look at facility accessibility, emergency planning procedures, communication procedures, policies regarding service animals, and staff training on disability access. The question is not just whether a policy exists on paper, but whether staff know how to implement it, and whether the organization is providing meaningful access in practice.
Next, we will move into Title IX of the Education Amendments of 1972, which prohibits sex discrimination. Title IX prohibits discrimination on the basis of sex in education programs or activities receiving federal financial assistance. For this audience, the most important point is that we are talking about education or training programs. And one thing recipients sometimes do not realize is that if one part of the organization falls under Title IX because it operates an education or training program, Title IX may apply more broadly to the organization. So, from a practical standpoint, organizations should make sure they have policies addressing sex discrimination, complaint procedures, equal access practices, and staff training in place. GSA is also updating its Title IX regulation as part of the broader move to the new CFR location, and we do plan to provide additional information and training as those changes move forward. The next core civil rights law is the Age Discrimination Act of 1975. The Discrimination Act of 1975 prohibits discrimination on the basis of age in programs or activities receiving federal financial assistance, unless the age distinction is specifically allowed by statute or regulation. So, for recipients, this means looking at eligibility criteria, age-based policies, and complaint procedures. If an organization is using age as a basis for limiting participation or eligibility, the question is not simply whether that makes sense operationally. The question is whether there is a legal basis for doing it. Sometimes there is. For example, a daycare program, by its nature, serves a particular age group. But where there is no statutory or regulatory support, an internal preference is not enough. Now that we have covered the major laws, we will discuss Section 2, General Recipient Responsibilities.
Regardless of which specific statute we are talking about, every recipient should have a basic civil rights infrastructure in place. That includes designating a civil rights coordinator, maintaining non-discrimination notices, including required assurances, maintaining complaint procedures, and making sure staff are trained. And I really cannot overstate the importance of training. One thing we see often in compliance work is that an organization may actually have decent policies on paper, but when you talk to staff, there is a disconnect between what the policy says and what staff understand. That gap is where a lot of problems happen.
When GSA conducts compliance reviews, we want to determine whether recipients have methods of administration that achieve compliance. That includes not only the existence of policies and procedures, but whether those policies are actually being implemented. Recipients are expected to cooperate during those reviews, provide requested documentation, and take corrective action where necessary. Another important piece of this is emergency planning. This is an area where civil rights obligations still matter and often become even more important. If a recipient is involved in disaster response or emergency operations, planning should include accessibility, effective communication, and non-discriminatory distribution of services. That matters because civil rights obligations do not pause during emergencies. In fact, emergencies often expose gaps that may not be obvious otherwise. So planning in advance is really what makes compliance possible when emergency conditions arise.
So, at this point, we've covered the legal framework. Now, I want to shift us into what this can actually look like in real life, because that's usually where the questions come up. The next few slides are just short scenarios. These are all based on situations we've seen before in one way or another. The goal is just to think through how these rules might apply in situations you could realistically run into. So, as we go through these, feel free to pause and think the scenarios through.
We usually prefer to work with organizations from certain communities. They're just easier to deal with.
I find that statement deeply troubling and exclusionary.
Let's say a SASP employee is talking to a potential donee, and during the conversation they say, "We usually prefer to work with organizations from certain communities. They're just easier to deal with." Later on, the applicant raises a concern about that interaction. Pause there for a second. What comes up for you when you hear that? Let's walk through it. Title VI prohibits discrimination based on race, color, or national origin. It's not just formal decisions that matter. Informal statements like this can also matter because they may reflect bias or intent. If something like this came in as a complaint, we would look at what are your eligibility criteria? Are they documented? Are they being applied consistently? Decisions need to be based on neutral, consistently applied criteria, not preferences or informal judgments. So the takeaway here isn't just don't say that. It's really about making sure your processes are clear, documented, and applied the same way across the board. All right, let's look at a disability access example.
Sorry about the steps, sir. If you head down to the loading dock, you can get in there.
In this scenario, a donee rep who uses a wheelchair arrives at a SASP warehouse. The main entrance has steps, so staff direct the person to use the loading dock instead. There is a ramp there, but the area is uneven and difficult to navigate. So the question is that enough? Let's pause. This is where it helps to think about the difference between access and meaningful access. Section 504 requires program accessibility. That means access cannot be denied, but it also cannot be inferior. Providing an alternate entrance might be okay in some cases, but it has to provide comparable access. Comparable does not mean we found a way to get you in. It means access that is reasonably similar to what everyone else is experiencing. So if the loading dock is hard to navigate or unsafe, that's where a problem comes in. And this is why we encourage recipients to look at things like entrances used by the public, routes of travel, restrooms if provided, and overall usability of the space. Because again, the question is not just is there access, but is it meaningful? Staying in the same general area of disability access, I want to talk about something that comes up a lot in practice, and that's service animals.
We need documentation proving your dog is certified.
I'm afraid I don't have that with me.
Then I'm sorry, but we cannot grant you entry today.
So let's say a PBC recipient operates a public-facing facility, and a visitor comes in with a dog. Staff say, we need documentation that your dog is certified. The visitor says they don't have that, and they're denied entry. So what do you think here? Let's pause. This is one of those areas where the rules are actually very specific. Staff cannot ask for documentation, certification, proof of training, or details about the person's disability. What staff can ask are just two questions. Is the dog required because of a disability? What work or task has the dog been trained to perform? That's it. And this is why training is so important. These situations happen in real time, usually at the front desk or point of entry, and staff need to know what they can and can't ask without having to figure it out on the spot. Now, that doesn't mean anything goes. If the animal is aggressive, out of control, or not housebroken, there may be a reason to remove it. But the key takeaway is that documentation is not required, and asking for it can create a compliance issue. All right, let's move into a Title IX example.
Morning, checking in for the leadership seminar.
Good morning. This program is specifically for the women's leadership track. We appreciate your interest, but it is reserved for female participants only.
So in this scenario, a donee runs a training program that receives federal assistance. The organization decides to limit participation to only one sex because leadership believes it aligns better with their mission. So the question is, can they do that? Let's pause. Under Title IX, the general rule is no, unless there's a specific legal exception that allows it. And this is a theme you'll see across these laws. It's not enough to say, this is how we've always done it, or this works better for our program. There has to be a legal basis for treating people differently. So the key takeaway here is that if you're limiting participation in any way, you need to be able to point to the law or regulation that allows it. Next one is a quick example under the Age Discrimination Act.
Effective immediately, organizations serving individuals in their 20s are no longer eligible for the program.
Excuse me, but what is the statutory basis for this change?
So let's say an SASP adopts a policy that organizations serving individuals under the age of 40 are not eligible for certain property. There's no legal requirement behind it. It's just an internal decision. So what's the issue here? Let's pause. Under the Age Discrimination Act, age distinctions have to be authorized by law. So again, it's not about whether the rule makes sense operationally. It's about whether there's a legal basis for it. Some age distinctions are perfectly fine. For example, programs designed for children or seniors. But if there's no statutory or regulatory support, then that kind of blanket rule becomes a problem. And last scenario. This one is about emergency situations.
How is she supposed to get up there?
I am so sorry. We didn't anticipate the mud. We're working on a solution now.
So Imagine during an emergency response, a SASP sets up a temporary distribution site. The site has no accessible entrance and no plan for individuals with disabilities. So, what should have been considered here? Let's pause. The key point is that civil rights obligations don't go away during emergencies. If anything, this is when they matter the most. Planning should already include accessible routes, communication access, and a plan for making sure people with disabilities can actually receive services. Because trying to figure that out in the middle of an emergency is usually too late. So those are just a few examples, but hopefully they help show how these issues come up in real everyday situations. And again, the goal here is not perfection. It's awareness and preparation. To close, I want to leave you with a few key takeaways. First, civil rights laws apply to all recipients of federal financial assistance from GSA. Second, there are some important regulatory changes underway, including new citation locations. Third, disability access obligations remain in place, including accessibility and effective communication requirements under Section 504. And finally, compliance is ongoing. It is not something you only think about during a review. A helpful way to think about it is to ask a few basic questions. Do we have a clear non-discrimination policy? Are staff trained? Do we have a complaint process? Are our programs and facilities accessible? Are we paying attention to regulatory updates? The goal is not perfection. The goal is awareness, preparation, and proactive compliance.
Please contact us if you have any questions or would like to request live training.